In a recent column in the Sydney Morning Herald, Mike Carlton recalled his grandmother, born in the late 1800s, speaking disparagingly of chinks, chows, Japs, Dagos, wogs, bolts, refos, evos and niggers. We have put that behind us now. The New South Wales opposition leader, Bob Carr, in 1989 was right when he said of the proposed racial vilification laws then, what will disappear will be the racist slurs such as coon, boom, slopehead and slant eye. These racial epithets, he said, will be thrown into the trash can of history where they belong. We generally accept this limit on free speech. We know that it is racist in a morally wrong sense to essentialise a person by reference to their skin colour and ethnic appearance. In this way, we can say we're not racist. And to a large extent, we can thank the fact, if not the operation, of anti-discrimination laws for this evolution. But it may be that all anti-discrimination laws and the sensibilities they bring with them have done is encourage us to not use those words, to avoid overt conduct, while failing to address the cultural values that sustain a more deeply held, passive, casual racism. Law has a small but significant, is that significant but small, I'm sure, part to play in achieving social change. Law has only so much to contribute to securing preferred behaviour in relation to race, as it is limited in securing any desired change in public behaviour. It is indeed a holy grail of law reform to be able to say when and how a law is effective in achieving change, but there's no doubt that law is not the whole of the answer. Education is the most commonly burdened strategy with achieving behavioural change, from school civics curricula to public information campaigns. Again, it's unremarkable to observe that no one strategy works alone. Lasting social change requires a range of complementary strategies. Community-wide attitudinal change is driven by many factors, only two of which, but the two that I focus on most, are the legislative settings of standards and enforcement of those standards. In a representative democracy, we can fairly accept that legislation does express community standards, or perhaps aspirations. At the same time, legislation backs up that symbolic power with enforcement. And over time, laws and their enforcement can achieve high levels of compliance when complemented by other mechanisms such as public policy, practice, political community leadership, public education awareness, education and training and so on. So in that larger context of strategies that may achieve social change, and keep in mind the underlying or perhaps the hidden nature of contemporary racism, anti-discrimination laws carry an unrealistic burden of achieving social change. They actually provide, as practitioners would know, little more than a remedial mechanism for individual grievance, with undoubted symbolic value of taking a public policy position against racist conduct. The unrealistic burden of social change imposed on anti-discrimination laws was seen very early on in relation to race. Writing in 1975 on the enactment of the Racial Discrimination Act, the UNSW academic, I think not insignificantly an expatriate Canadian, Brian Kelsey, said of the Racial Discrimination Act then, it exhibits no evidence of the required reappraisal of basic postulations, cultural or legal, and in fact makes no effective provision for implementation of the Racial Discrimination Convention in Australia. Kelsey pointed out that a complaints-based procedure is directed towards racial discrimination in its narrowest sense. It needs to be understood, he said, that acts of individual race discrimination are only a reflection of institutional racism, which is not a series of acts, but rather a total act of one group vis-à-vis another. It is difficult, he said, to envisage the Racial Discrimination Act making any significant contribution to the elimination of racist attitudes. That was before the Racial Discrimination Act was amended to incorporate racial vilification provisions. I don't know, he's since died, what Brian Kelsey would make of the racial vilification provisions. Within anti-discrimination laws, the provisions that target vilification are in fact different. They are an attempt to do what Kelsey said the Racial Discrimination Act otherwise doesn't do. They're an attempt to make a contribution to the elimination of racial attitudes. Vilification laws dig a bit deeper. They try to expose racist attitudes that simply exist unconnected with treatment of workers or circumstances of providing accommodation and so on. They attempt to do more than ensure that people are not treated unfavourably because of their race. They try to ensure that people are not even thought of unfavourably because of their race. Our early anti-discrimination laws didn't incorporate protection against vilification. The New South Wales legislation, on which all other legislation in Australia except the federal provision is modelled, was the first in 1989. Other states in the ACT followed, but they were given real impetus by the fact, if not the form, of the federal amendments in 1985. These laws that prohibit racist speech, clearly limit free speech. The current debate is essentially over the degree to which speech ought to be limited. What can be said before a line is crossed? The sooner the line is crossed, the sooner there is an encroachment on freedom of speech. Now, the line is a fair way away under the state and the states and ACT laws because they're concerned to prevent speech that incites some or all of hatred, serious contempt, revulsion and severe ridicule. The federal provision, section 18C, draws the line relatively close. The federal provision is concerned to prevent speech that may offend, insult, humiliate or intimidate, a fundamentally different test. But, as I want to illustrate, the line drawn by 18C and the resulting encroachment on free speech is not as close as it may seem. The Attorney General, Senator Brandis, has an enthusiasm for what he calls traditional rights. I've worked out that these are the fundamental common law rights that some members of the High Court choose to protect under the principle of legality. Under that principle, the courts will not interpret legislation as abrogating or contracting fundamental common law rights unless that was clearly Parliament's intention. Senator Brandis has asked the Australian Law Reform Commission to review all Commonwealth legislation to report on laws that unreasonably encroach on traditional rights. So, a question for the Australian Law Reform Commission is going to be whether 18C, read with the very broad exceptions in 18D, is such a law that unreasonably encroaches on the common law right of freedom of speech. There's actually some guidance on this question in a 2013 High Court case, the Crown and Monis, where the court had to consider whether the law against using a postal service to cause offence encroached on the fundamental common law right of free speech. And Justices Crennan, Kiefel and Bell, noting that legislation concerned with the regulation of communications usually attempts to strike a balance of competing interests, in that case free speech and not being subject to offensive conduct. They said that a law against using a postal service to cause offence finds that balance when offensiveness is understood to be at the higher end of the spectrum. Words, they said, such as very, seriously or significantly offensive are apt to convey this, which is just what we find in the jurisprudence on section 18C. To offend, insult, humiliate or intimidate are profound and serious effects, not to be likened to mere slights, said Justice Kiefel when she was sitting in the federal court in Creek and Cairns Post. And that view was endorsed by Justice Healy and Jones and Scully, who also cited the then Attorney General's second reading speech for section 18C to the effect that the language deals with serious incidents only. So I think that much of the Australian Law Reform Commission's vast task of reviewing Commonwealth laws, I presume to have done for them. Section 18C, as the courts have interpreted it, read with section 18D, the broadly permissive exception, does not unreasonably encroach on the right to free speech. It is odd, however, I think, that we're discussing racial vilification laws by reference to fundamental common law rights. There's no common law right that protects against racist conduct. The source of section 18C in our laws against racial vilification is the International Convention on the Elimination of All Forms of Racial Discrimination. It's an international human right. Specifically, Australia gives effect to its obligations to prohibit racial discrimination, to combat prejudices which lead to racial discrimination, and to promote tolerance. Section 18C's undoubted limiting of free speech needs to be judged in that context. Not, however, I suspect, by Senator Brandis. In a 2010 Senate committee hearing into the proposed human rights scrutiny legislation, the then Shadow Attorney General, declared that he is, quote, very sceptical of the wholesale invocation of the international jurisdiction surrounding the human rights treaties, preferring, he said, quote, the accumulation of rights through both the common law and statutory protection going back literally centuries. Now, in the brief analysis I just gave, I've deferred to the Attorney General's preference, and I have assessed Section 18C by reference to the common law going back literally centuries, and I have not found it wanting, but I suggest on the basis of High Court authority, it sets the bar or draws the line at an appropriate point. That is how I think the High Court will deal with it under the principle of legality. But despite the Attorney General's scepticism, Australian legislation is now assessed by reference to the human rights treaties. And were Section 18C to be subject to such scrutiny under the federal legislation, it would, in my view, be endorsed again as protecting the right to be free of racial discrimination in terms that are reasonable, necessary and proportionate as an encroachment on the right to freedom of expression. It's a trade-off. And I'll look a little more closely at the nature of that trade-off. The balance is between the loss of a degree of free speech for the sake, or the trade-off is the loss of a degree of free speech for the sake of protecting against racist harm. I'm going to focus on the idea of harm as being that against which free speech is balanced. Speaking in 1989, Bob Carr, in relation to the New South Wales Bill, said, this legislation of the New South Wales provisions gives a legal voice to victims who can articulate their hurt. In fact, that's just what the New South Wales legislation doesn't do, nor does any of the equivalent state and territory legislation. The incitement to hatred model of vilification doesn't give legal voice to victims. It condemns those whose conduct is likely to incite hatred, but it's silent as to the effect of that conduct on the victim. If a person is attacked by racist speech, they have a remedy under those laws only if they can show that others are likely to have been incited to hatred and so on. That depends on a very particular set of circumstances, and the case law shows that it's a high bar to get over. Uniquely in Australia, the federal provisions are concerned with how racist speech makes a victim feel. This shift in perspective from perpetrator to victim is consistent with an ethic of care, an idea some of you would recognise from feminist jurisprudence, where justice is done not solely by reference to the degree of departure from an authoritarian norm, but by reference to the harm that is caused by that departure. Where law once exercised only responsibility to prevent conduct, increasingly it is exercising care for those who have been harmed by the conduct. In criminal law, impact statements now give voice to the victim, recognising that regulated conduct doesn't happen in isolation, but is part of a network of relationships and has consequences for others. I'm unsure, in my thinking so far, when and to what extent an ethic of care in legal regulation is always going to be apt. But it holds the promise of a significant advance on the dispassionate, declaratory nature of law, and suggests a more contemporary sensibility, responding to what has happened as well as what ought not to have happened. This, I think, is the special character of 18C. This is what we risk losing. A provision which doesn't regulate racist conduct from above and outside, by declaration of wrongdoing, but from within, by responding to harm that the regulated conduct has caused. The ethic of care characterisation that I'm giving 18C is, I have to say, my own gloss on 18C well after its enactment. In fact, 18C reads as it does by accident. The current wording was intended to be a criminal provision, and parliamentary amendments saw the provision retain its wording and its race hatred heading, but shift from being enforced by criminal sanction to being enforced by civil complaint. With those origins, it's in fact unremarkable that 18C is concerned with causing offence, because criminal law provisions commonly outlaw the causing of offence. Summary offence laws, postal laws that I've mentioned, and so on. But however it came about,